Ladies and gentlemen, I welcome all to my channel. Today we are going to see the CMDA Act, Chennai Metropolitan Development Authorities Act, and we will also going to see what is meant by stop work notice, lock and seal demolition notice, deoccupation notice, discontinue occupation notice, and the procedure to be followed for filing an appeal as against these orders, the ways and the remedies available to the parties who received this lock and seal or discontinue lock and seal demolition notice or the discontinue occupation notice. Nowadays in Chennai, several persons, several landowners receive notices like this: lock and seal demolition notice, stop work notice, or discontinue occupation notice, etc. And they are all facing a lot of problems, and they do not know what to do with this notice, how to solve this notice, how to face the proceedings, how to resolve these things, how to come out of this issue. As per the CMDA Act, rules and regulations, and as per the Municipalities Act, every owner should get the required planning permit, planning approval, building permission before the construction of the house. It is a mandatory to every owner to get proper building approval, planning approval for the construction of each and every building. So this planning approval can be obtained from Corporation of Chennai if the building is within their limits, say ground plus 2 floors or row plus, or within a specified area. If it is in the property is located within the limits of municipality, then they will have to approach the concerned municipality and they have to obtain the planning permission. For multi-storey building, you will have to approach CMDA. If the building is constructed within the limits of the planning permit, then you will not have any problem. If there is a violation, or if you construct a building without any building approval, or if you construct a building, if you obtain a building permission for ground plus 1 floor and constructed second floor or third floor unauthorizedly, then automatically you will all get problems from CMDA or from corporation or from municipality, and they may issue these stop notices, lock and seal demolition notices, discontinue occupation notices, and they may also take any action to demolish the buildings. See, the stop work notice is issued under section 56 of the CMDA Act. So normally the assistant engineer of corporation issues the stop work notices. So as per the old Act, this stop work notice can be issued to those building which is commenced its construction within 3 years from the date of notice. Supposing a person commenced its construction within a 1 year or within 2 years or with maximum 3 years, then as per this old Act, the corporation authorities and CMD authorities have the power to issue this stop work notices. If the work was not stopped within that period, then automatically the next notice will be issued, which is called as lock and seal and demolition notice. In the stop work notice, the authorities will ask the owner to stop the work After 15 days, the same authorities will issue another notice. It is called as Lock, Conceal and Demolition notice. In this notice, the authorities will ask the persons, owners, to lock and seal the premises and to demolish the unauthorized constructions and to demolish and remove the additional construction which was constructed in violation of the approved building plan, or if it is constructed without uploading any approved plan. So this is the second notice. After this notice, or after 15 days, then the authorities will start that will be forwarded, the matter will be forwarded to enforcement wing. Then they will issue the third notice, which is called as discontinue the occupation or deoccupation notice to all the occupants of the building. This notice is normally issued to the tenants, occupants, owners, and they will say in the notice that the authorities are going to demolish and they are going to take stringent action for restoration of the building. They will ask the occupants to vacate within 15 days. So this will be a threatening to all the owners, occupants, residents, tenants. So now, what is the remedy available to all these peoples who receive these notices? Strictly speaking, under the old Act, this kind of notices can be issued to those buildings which were constructed within 3 years from the date of issue of the notice. This Act was amended, it seems, in the year 2009, it seems. The terms within 3 years from the date of commencement of the building, this word was removed from that Act. So, as per after this amendment and after the modification of the Act, the CMDA authorities, the corporation authorities have the power to issue notices to any building which were constructed even prior to 3 years. Supposing the building was constructed 10 or 15 years back, even to that building they can issue the notices, because with the words within 3 years from the date of the commencement of the building were removed under the Amendment Act, so they can issue to any building. The argument of the owners, the submission of the owner is that my father has constructed the building, my grandfather has constructed the building, we are paying the property tax for 15 years, the building was assessed for 15 years for property tax, the building was assessed for drainage connection, water connection, and we also obtained electricity. So the government has already approved this building by way of assessing the building for property tax, assessing the building for water and drainage purposes, and by approved our building by way of giving proper electricity connection, and we have been paying the rent for we have been paying the property tax, water tax, drainage tax, charges, electricity charges for about 10-15 years. Then why are you unnecessarily troubling us after a period of this time? This was the painful argument, submissions made by our owners. It is really unfortunate to those persons who receive these notices. Now, as per the law, the government can issue this type of notices to any persons. The law permits. They have, under the law, they have the power. Those seems to be an arbitrary power. We cannot say that, we cannot question the issue of these notices. So the one and only remedy is you have to file an appeal. You can file, the persons who received this notice can file an appeal within 3 months to the government, to the state government. So under section 80 and 80A of the Act, a person can file a revision petition to the government as against any decisions, any notices, as against any demolition notices, as against the deoccupation notices. So that will be considered by the concerned governmental authorities who are sitting in Fort St. George. So if you receive any notice, you have to file a revision petition. You will have to take all possible defenses, all possible submissions, and you can file this petition under section 80 and 80A of the Act to the government. So that will give immediate relief to you. You can also file a stay application asking the government to stay all the notices issued by the corporation, assistant engineer, assistant executive engineer, zonal engineers. So that by way of filing this appeal or revision petition, you can temporarily stop the activities, the demolition activities, the lock and seal, threatened activities of the corporation authorities, and you can also file stay application. So this will help you to stop your threatenings, demolition work for a temporary period. As per section 113 of the Act, if there is a violation, you can also apply for regularization. Initially, the parties were allowed to file eviction regularization application to the government. Now the government itself has declared schemes in where initially the government declared a scheme through which all the buildings constructed before 1987 were permitted to be regularized by paying a nominal fine or penalty. Subsequently, this regularization scheme was extended then and there. At present, I think up to 2007, all the buildings constructed up to 2007 are entitled to be regularized under the regularization scheme. So for this thing, if your building was constructed before 2007, you can file an application for regularization by submitting all the required documents. So there is some procedure is there. You will have to file detailed plan of the existing structure with stability certificate, legal opinion from a notary like me, and we will have to pay nominal application fees. And if it is a multi-story building, they will also ask for a NOC from Fire and Safety Department. So if all the necessary fees are paid and all the documents are submitted, the CMDA authorities will give a regularization and give approval, legalize, and they will legalize the unauthorized construction which were constructed before 2007. So as per the present scheme, this scheme was available only to those buildings which were constructed before 2007. It was not available. So you cannot apply a regularization to a building which was constructed recently. So only those buildings which were constructed before 2007 are alone make an application for regularization, and by submitting the required documents and by following the procedures incorporated under the stipulated under the rules and regulations. If you are not able to So first way is to file the first, if you are the first way to come out of this demolition notice, lock and sale notice is by filing a revision petition to the government. The second option is to get a permanent relief is to file a regulation application before the CMDA to regulate those buildings which are constructed prior to 2017. If it is possible, you can also make necessary application before the government and seeking some relief and seeking some guidance from the government to remove only the minimum deviation works which will not cause any damage to the existing building. So even if you are not able to successful in the first way revision application, then the last option available to you is you can apply the modification plan. You can show the existing building and you can suggest your modifications. As per the old law, the FSA available to the building was 1.5. The FSA means the floor space index. So before 2017, I think, 2017 or 2019 it seems. 2019 it seems. If you have obtained any building plan, you would have obtained the plan within the limit of 1.5 FSI. FSI means floor space index, which means if you have land of 1000 square feet, as per this CMDA rules, you are entitled to construct 1500 square feet of built up area. Assuming you have a land 1000 square feet, you have left the ground floor for car parking and you constructed a first floor for your residential unit, then you are also entitled to put up second floor up to the limit of 500 square feet. So ground floor, first floor, ground floor is totally left for car parking. That will not be taken into account. The first floor 1000 square feet you have constructed, and second floor you are entitled to construct 500 square feet. So for the land of 1000 square feet, the FSI 1.5 FSI will come to 1500 square feet built up area. So you will be permitted to construct 1500 square feet built up building as per the old law. Now after 2019, the limit, FSA limit was increased to 2. So 2 means now you are entitled to construct another 500 square feet. So you are entitled to get 2000 square feet built up area construction. So supposing you have a building approval under the old act to the limit, to the extent of 1.5, now you can file a revision application or you can modification plan, alteration plan, and you can enjoy, you can get the additional FSI of 0.5 and you can get revised planning approval for your building by making an additions or alterations, modification, and by filing necessary application to the land. That is also one of the attempts, one of the procedure, one of the ways available to those persons who receive these notices to come out of this issue. So, in order to make it clear, I just wanted to brief you again. So, if you receive any notices of workload of this nature, you can file revision application under 80 and 80A to the government. That will give a immediate relief. You can also file an application for stay application. Then you can also apply for regularization. If all these things not fruitful to you, then you can go for fresh application for the modification or alteration of your building plan, and by through that you can claim two FSI, for which you can also make a application for alteration, modification, additional building plan. That will also helpful to you. I hope this video is useful to you, useful to the persons who receive these notices. So I request you to give a comment about this video, which will be helpful to me. If any of your friends or relatives or known persons received any such notices from CMDA or corporation, they may require this kind of advice. So you can share this video to them, which will be helpful to them to know about the way to come out of this issue. I have posted several videos. I have 2 channels. Raziaq Sattam Arivom is my Tamil channel, where you can watch hundreds and hundreds of videos in Tamil. This is the law channel. Raziaq Law Tube is my English channel. In this English channel also you can view and watch various videos covering various topics. So if you have any legal doubt, you can watch any of my 2 channels. You can also go through the playlist topics that will be helpful to you to acquire legal knowledge on the particular topic and to come out of your legal issues and to get proper remedies. Knowledge is power. Legal knowledge will not only give you the power and strength, but it will also give you the enormous support, stability, with which you can be a strong man in this society. So please watch my videos continuously and acquire the required legal knowledge and share it with your friends and relatives. And if you have any, in spite of these videos, you are not able to come out, if you need any further clarification, legal opinion or legal assistance, you may contact me. You can contact my phone number and we will give you the required legal assistance or legal opinion. I hope this video will be useful to you. I will come again with another topic. Until then, goodbye. Raziaq Ali.